Not every unpaid debt needs to go to court. In Vietnam, many businesses recover overdue payments without filing a lawsuit, through an approach often called soft collection. It is structured, persuasive, and cost-efficient when used at the right time. In this video, we explain what soft collection means, why it can work well in Vietnam, and when it should be your first move, especially for foreign companies dealing with overdue invoices or contract payments. Soft collection refers to non-litigious, pre-legal recovery efforts. There is no court filing, no lawsuit, and no formal hearings. Instead, the strategy relies on organized communication, negotiation, and formal notice, delivered with consistency and credibility. It can include phone calls, emails, meetings, structured payment discussions, and lawyer-drafted letters that clearly state the debt position, supporting documents, and next steps if the issue is not resolved. The goal is simple: recover payment quickly while preserving business relationships and avoiding unnecessary legal cost. In many commercial settings in Vietnam, counterparties prefer to resolve disputes privately rather than move immediately into formal proceedings. Delays sometimes happen due to cash flow pressure, internal approval processes, or fear that escalation will damage reputation or operations. When approached properly, with clear facts, a professional tone, and a realistic path to resolution, many debtors will engage and settle rather than risk a larger dispute. Soft collection works because it creates structure and urgency without forcing a courtroom timeline too early. Soft collection is often a strong fit for foreign suppliers, manufacturers, service providers, and investors who 1. Want to preserve a workable relationship. 2. Face delay rather than clear fraud. 3. Need speed without procedural complexity. Or 4. Want to test settlement potential before committing to litigation. It is often most effective when started early, commonly within the first few weeks to a few months after a payment becomes overdue, while the debtor is still operating and evidence is fresh. At LTS law, soft collection is not chasing. It is a controlled process. A typical plan includes 1. Debt file review, contract terms, invoices, delivery, acceptance records, and payment history. 2. Positioning strategy, deciding the tone, leverage points, and settlement boundaries. 3. Structured outreach sequence, a clear contact plan with deadlines and escalation checkpoints. 4. Negotiation management, calls and meetings focused on commitments, not excuses. 5. Escalation planning, communication stays firm, accurate, and compliant, without triggering unnecessary resistance. Importantly, we document communications in a way that can support the evidentiary record if escalation becomes necessary. Many companies assign sales or finance teams to pursue overdue payments. That can work for small delays, but when a debtor starts stalling, internal follow-ups often carry less escalation credibility than counsel-led communication. When a law firm leads soft collection, the conversation becomes more disciplined, the claim is framed in legal and contractual terms, deadlines are defined. And the debtor understands that the creditor is organized and ready to escalate if needed. The result is not harshness. It is clarity and seriousness. A foreign supplier faced a significant overdue balance after repeated delays and vague promises. Instead of filing immediately, a lawyer-led soft collection plan was launched. A formal notice with supporting documents, coordinated follow-up calls, and a structured meeting focused on repayment capacity and deadlines. The debtor then agreed to a staged repayment plan and began paying shortly after. Details adjusted for confidentiality. The key factor was structure, clear evidence, clear timelines, and credible readiness to escalate if commitments were missed. Soft collection is not a universal solution. It is less effective when the debtor is likely insolvent, clearly evasive, or consistently unresponsive. It may also be unsuitable when assets are at immediate risk of being moved or when the dispute involves serious allegations beyond payment delay. In those cases, a slow approach can waste time and reduce recovery prospects. That is why a pre-screening assessment matters, so you start soft only when it is rational. Soft does not mean forever. If the debtor misses agreed deadlines, refuses to document commitments, or shows clear evasion signals. The strategy should shift quickly to arbitration or court, based on your contract and enforceability objectives. The smartest approach is staged. Begin with structured soft collection, then escalate decisively if cooperation fails. If your company is facing unpaid invoices or overdue contracts in Vietnam, start with strategy, not assumptions. LTS Law can design a compliant, lawyer-led soft collection plan tailored to your case and commercial goals, and help you escalate at the right moment if necessary. Visit lts.com.vn to begin your recovery process professionally and effectively. Because in Vietnam, disciplined action often secures payment faster than noise.